Good afternoon, everyone. Thank you for joining us. Our team from Loeb & Loeb is going to talk to you about everything you wanted to know, but were afraid to ask or not afraid to ask about the new endorsement guides. And we're excited to talk with you about this topic. I'm joined by my colleagues from Loeb & Loeb, Jenny Savitt and Libby O'Neill. We are all attorneys in the Advanced Media and Technology Department at Loeb. And this is an issue that's really important to us and to our clients. And if you're an attorney and you're active in advertising and media or entertainment, whether you're a brand, agency, or talent, you probably touch upon these issues. And one of the things that triggered this is earlier this summer, the FTC finalized revised endorsement guides. And we thought it was a good time to kind of get a handle on where we are with the law and where we are with the guidance. So if we can move ahead on the slides, I'll just share with you what we're hoping to accomplish in this hour here. We'll give an update on the FTC guides in terms of what has changed, what's new, what do we need to know as attorneys in this space. One of the hot issues that everyone talks about is what's going on in social media and with influencers and this issue of disclosing material connections. But that's not the only issue. There's a renewed focus on customer reviews, including some proposed rulemaking that we'll talk about in terms of the consequences. We'll touch on the recent enforcement action in terms of what are the actual risks and what's the conduct that FTC is looking at, and also take a quick look at self-regulation, at NAD, and the role that they play in this space. And hopefully we'll have enough time to talk about what I think is going to be most important, which is some of the real-world examples, practical tips for navigating this space. This is CLE, stay tuned. We will be able to offer a CLE code as this presentation goes on, but we know you're here not just for CLE, but for the substance, and we're eager to get into the substance. So with that, let me turn it over to Libby, who's going to start by sharing with you where we are now in this space and how we got here.
Great. Thank you, David, and good afternoon, good morning to some folks. Thanks for joining us, and thanks, David, really for laying the table nicely there in terms of what we're going to talk about today. This slide is titled, "Why Are We Here?" I think David sort of answered that question nicely, and I hope, frankly, you sort of know generally why we're here. If you want to hear about eminent domain, you've got the wrong webinar. You should sign off now. But what we're going to talk about is maybe more appropriately, how did we get here and why does it matter? So basically, until the FTC released the draft guides last year, we were still working with guidance from 2009, which doesn't sound that long ago necessarily. But if you think about how much the landscape has changed, it's kind of a lifetime ago, right? If you think about it in advertising terms, companies in 2009 may have been doing like almost entirely traditional media buy, working with linear and radio and out of home. And now we're seeing those same companies have, maybe the almost entire media buy in digital and new media space, and really focusing on influencers and the social media space, so that this is becoming ever more important in sort of the strategy for advertising products and services. So the FTC's guidance from 2009 really didn't reflect that. Reading through the old guidance is actually kind of funny, because some of the terminology like buzz marketing, and there's a big emphasis on bloggers, all feels really old-fashioned, I think, at this point. So there was the need, first of all, just to update that, right? That's one reason we got here and why we're here today. Another reason is also the FTC's sort of evolving strategies and need to seek appropriate monetary penalties, right? We saw in 2021 with the decision in AMG Capital Management versus FTC really had a sort of a blow to their ability to collect penalties, that was related to Section 13B and their right to seek injunctions, but also monetary penalties. And they sort of lost that ability and have been looking for creative ways to get back in that game since then. I'm thinking particularly of the notice of penalty offenses that the FTC sent out in 2021, and also the notice of proposed rulemaking on reviews and testimonials, which Jenny's going to talk about in a bit. But right, so money is one thing, but also let's talk about the underpinnings of the guides and sort of, the basis for why we're here entirely and why these are so important. So the guides are just that, but the underpinning is Section 5 of the FTC Act. And Section 5 prohibits unfair methods of competition in or affecting commerce, which is pretty broad. And it includes false advertising, which is defined as an advertising that is misleading in a material respect. Okay, so like, what does that mean? How do we define that? And the guides, I think, really seek to answer that question and answer it pretty clearly in a conspicuous way, if I can use one of the FTC's own terms, right? They represent, I think, FTC's position that advertisers have been getting sort of too clever by half in terms of how they might be interpreting this concept of endorsement or endorser, or even clear and conspicuous itself. And some of what we're going to talk about as I go on here is the very fact that the FTC is saying, let's get really clear on what those mean. Endorsement is pretty broad, and clear and conspicuous means pretty clear and obvious. The term that we're going to talk about is unavoidable, right? So, if part of the strategy has been what are ways that we can interpret these words because they're not defined so that we can get away from some responsibility in this area, I think the FTC is trying to close that gap a little bit. So one last note before I move forward, in addition to the standard caveats we provided, the opinions in this presentation are our own, which of course they are. And while of course developing guidelines and best practices are going to help, I think in 90% of the cases, in a lot of situations, just to sort of have good guidance at the core of your strategy, there are going to be a lot of it depends here, right? Context is really going to matter. The FTC tells us specifically that audience matters. So if you are advertising primarily to an audience of digital native Gen Zers who might understand shorthand and disclosures a lot more clearly, that might be a little bit of a different standard for what's misleading than if you are advertising primarily to a group of older consumers who might not have as much familiarity with hashtag ad or hashtag brand partner or similar kinds of disclosures. And keeping that in mind is going to matter. So when lawyers and in-house lawyers and outside counsel are reviewing this, part of that is going to depend on the context. The other thing that matters is the channel, and even within the channel, the sub-channel, right? So the way that you might treat an Instagram grid post versus a reel versus a series of stories is also going to be different. And I think that we have to kind of keep that in mind as we go and always come back to base principles that we're trying to avoid being misleading. We're just trying to have the consumer, understand material connections that exist, whatever those might be. So let's get on to the next slide. Believe it or not, we're actually going to move on. One thing to say here is if you've been scratching your head thinking these guides came out in 2023 and like they look really similar to last year. Am I missing something? Am I crazy? You're not. They are really similar, right? The FTC put out draft guides in May of 2022. A lot of people had a chance to read those. There were a lot of law firm posts and updates at that time. For folks on the call who are in-house counsel who may have worked on updating guidance, you may have done that last year. And these guides that are final are really nearly identical. There are some new examples that are included. There are also some clarifications for some language that might have been a little bit tricky to understand. There are a couple substantive additions. So one that I'll note particularly is that the FTC really clarified the kinds of reviews that you can reasonably suppress, things that are profane or obscene or that sort of thing. That wasn't included last year. But for the most part, what we're seeing is the FTC affirming kind of what they already came out with last year, notwithstanding all the comments they received. So yes, it does look similar, but let's get into what the differences are. If we go to the next slide. So I alluded to this before, but the FTC has made very clear that endorsement is broad, right? So to the extent that there's been any sort of desire to contract the definition of endorsement as you're deciding what counts as an endorsement or testimonial, the FTC has said no. Understand it includes verbal statements, it includes tagging in social media, right? It includes demonstrations, signatures, it could include seals of organizations. There are a lot of things that could count as an endorsement. So considering all of those taken together, I think will help create a sort of fuller picture of what an endorsement can be. And one of the practical examples we're going to share later, we're going to look at something where we're seeing a brand tagged, but maybe not clearly identified as having a material connection to the influencer, and considering that is going to be really important. It's not just saying I like and endorse this product. It's much broader. And by the way, I've done this so far, and you'll notice that I may do this a bit more, and all three of us will go back and forth between this concept of endorsement and testimonial. The FTC treats them as synonymous. Why they have different names might be a different conversation for a different day, but we know that they're treated as synonymous by the FTC. If we go on to the next slide, clear and conspicuous. So clear and conspicuous didn't used to have a definition. It does have a definition now. It was much more flexible in the 1980 guides and the 2009 guides, and the FTC actually spoke about that and said, part of what we're doing is sort of allowing context to dictate what this can mean, and giving a little bit of freedom to determine, what's clear in one situation and conspicuous. And they said specifically, we're trying not to be necessarily too prescriptive. And I think that they've really walked that back, right? Because now we actually have a definition that clear and conspicuous, we're told that disclosures have to be difficult to miss, easily understandable by ordinary people. But more than that, the FTC says, as I said before, they've got to be unavoidable. What they're saying is, were you trying to put them at the end of a series of hashtags? Were you trying to bury them or make them hard to see, or perhaps include them in one frame but not another? They need to be unavoidable, and they need to be unavoidable to your audience. So is your audience children? Is your audience older folks? Who is it? They've got to be very clear. More than that, I think, and something that I've seen a ton of questions, and that I completely understand is driving brands kind of crazy, is the idea that if a claim giving rise to the need for a disclosure is made verbally, you've got to have a verbal disclosure. And if the claim is made visually, you need a visual disclosure. And wait for it, if the claim is made both ways, you have to have the disclosures go both ways. So we're going to talk about some practical applications of that later in the deck, but I certainly appreciate that it's one thing to have gotten used to perhaps the concept of having a hashtag ad superimposed over videos that you might have people doing, but to add in a verbal disclosure could potentially feel a little bit more onerous. And I think that there are probably ways, depending on the context, there are ways to do it that don't go over the top or don't make it seem too out of place in the influencer's work. So we can go to the next slide. And I know the questions are coming in. I'm going to try to come back to a couple of them just so I'm not reading questions at the same time that I'm speaking to folks. So something to keep in mind too, when we're thinking about all these new and exciting things is a lot of the concepts that existed in the 2009 guides still absolutely exist, and in some cases are just affirmed even more. So for example, typically speaking, we want to see the experiences that people are sharing represent a typical consumer experience. And the FTC told us in 2009, and they've agreed with themselves now, that just saying something like results not typical is not going to be enough to get around confusion. When somebody is broadly and brightly spouting out their amazing experience with, a weight loss product, for example. What could work in that situation would be to say what the typical results would be, and keep in mind that explanation of what the typical results would be, if different from what you're showing on screen, would need to be clear and conspicuous and unavoidable. So you've still got that requirement. Product reformulations is another interesting one that the FTC talks about. You've got to be a bona fide user of a product at the time an endorsement is given. And the FTC tells us that this can be handled in different ways. So as an example, if you're a user of a product and you give a testimonial about that product, and the manufacturer of the product has an advertisement sharing your testimonial saying, you love the product, if they reformulate in a material way that really changes, the quality of the product and, makes a difference. The FTC uses an example of a paint that would have had to have 2 coats to work and now only needs 1 coat, right? So that's a pretty big difference in terms of time and experience. Then the manufacturer needs to go back and get a confirmation that the endorser still sort of agrees with the endorsement that they gave before the reformulation, or they can give a new endorsement that has to do with their use of the new reformulated product. What's different is if the person at the time they used the old product put up something on social media, you don't have to pull it down just because the product has been reformulated. And if it's true as to your experience with that product that sort of exists in that world, and the date is on there, so it's clear when you made that disclosure, it's okay to keep that up. Let's, if we switch that around a little bit and say, let's say that you use something, the product wasn't reformulated, but in subsequent uses, you've realized that it actually doesn't work as you thought it did, or you don't have a good experience with it anymore. Endorsers have an obligation to take those endorsements down because they're no longer true. And endorsements should represent somebody's actual lived experience with a product. We can go to the next slide. Okay, so liability. This is new. The 2009 guides referred to advertisers, and still advertisers are, I think, we can expect to see advertisers continue to be at the center of the FTC's enforcement priorities, right? And the FTC kind of gives more specific guidance to advertisers in terms of how they should monitor compliance with the guides. But the FTC has added some clarity on liability with respect to endorsers and intermediaries, specifically, advertising agencies, PR agencies, other kind of third-party vendors who may be included in the production, creation, the pushing out of content. So on the advertiser front, advertisers need to ensure that they're providing guidance to endorsers on how they can comply with the guides, that they're monitoring that compliance. So it's not enough just to tell people what to do and to put it into their hands. There has to be monitoring of that compliance as well. And then also that advertisers need to take action sufficient to remedy non-compliance. What does that mean? It can mean different things for different people. Typically, what we would see is something like, remedial action on quick, like 12 to 24 hours to correct a post, for example, to change it to make it, accurate if it's not accurate, or to have a disclosure of material connection if that's not appropriate. And, after that, a takedown of the post. And if there's sort of non-compliance at that point with the endorser or the testimonialist, then, hopefully you've got some contractual remedies that you can put out there as a stick. And we'll talk about contracting a little bit at the end if we have time. On the endorser front, endorsers need to make sure, as I said before, that they're sharing accurate and honest experiences, and that it should be sort of, if the experience that you're sharing is, I used this once and I really enjoyed it, okay. But if you're saying I use it all the time and it's great, then make sure you actually use it all the time, and that you can stand behind that. endorsers shouldn't be sharing information that they know or should know to be false, or that goes behind the kinds of substantiation that an advertiser has provided. And beyond that, endorsers shouldn't be sharing posts that weren't approved by an advertiser. So obviously, an advertiser has this liability, or is on the hook to monitor compliance. But part of the story an advertiser might have to tell the FTC is, we monitor compliance. We didn't see this. They did not get this approved. Here's our approval process. It wasn't approved, and an endorser might find themselves on the hook. With respect to agencies, let's say, if you're helping to produce, review content, get content out in the world, agencies also need to be sure that the content doesn't include information or representations they know or should know based on information they've been provided to be false. Also, letting posts go out the door that don't adequately disclose material connections could put a third party on the hook. One question I can answer really quickly is, yes, this recording will be shared with attendees. So if you're having issues with your internet connection or with Zoom, we will share it. We can go to the next slide. I'm going to spend only a little bit of time because I am aware that time is slipping through our hands, believe it or not, and just talk about the fact that the new guides really spend a good amount of time themselves on review practices. So this is guidance, but of course we're going to get into a notice of proposed rulemaking, which would codify some of this in a second. Specifically, the guides remind advertisers that they shouldn't procure, suppress, boost, organize, a bunch of words, reviews in a way that would be misleading. Practically speaking, some of that remains to be seen, but I think that one thing we know is that, it suggests sort of giving equal treatment to the same kinds of reviews on opposite sides of the negative positive coin. As an example, we know that, you can have a policy that you don't publish reviews that have profanity in them, but if you only apply that to negative reviews and let all the F-bombs go out because the people love your product so much, that would be unequal treatment and would be, if it were discovered, would be a practice that would be sort of suggested against in these guides. The other thing, I mentioned this earlier, that the guides did substantively change from the 2022 draft to now is really clarifying that in addition to this sort of question about profanity or that sort of thing, that if reviews are unlawful or harassing or abusive or obscene, there are a lot of sort of categories that you can keep out that don't have to do with just suppressing negative reviews. And it's important to remember that, because oftentimes reviews that are obscene and vulgar and harassing tend to be also negative just because people are angry. But if the reason that you're suppressing them is because of that kind of inappropriate conduct versus the very negativity of them, that is, we're told that is probably okay. So just, again, having a really clear policy on this is going to be important. And Jenny will get into specific ways that the FTC wants to enforce that. I'll turn it over to you, Jenny.
All right, thanks, Libby. So, as we've mentioned, the day after the FTC issued their updated endorsement guidelines, it published this new notice of proposed rulemaking. It's entitled the Trade Regulation Rule on the Use of Consumer Reviews and Testimonials. So this new rule comes after the FTC has initiated several actions against companies who have allegedly engaged in deceptive practices regarding consumer reviews. So whether it be suppressing honest reviews or soliciting fake reviews, we've seen the FTC really focus in on this area. And as Libby mentioned, this new rule is in line with the FTC's guidance in the endorsement guides regarding consumer reviews, but it goes one step further in the fact that it would codify their beliefs and allow them to impose monetary penalties on an advertiser who engages in this type of deceptive behavior. And so while we were previously left to assume that consumer reviews were endorsements, the FTC is now making it, pretty clear that that's how they view it, depending on the circumstance. We know the impact that reviews have on buyers' purchasing habits. Companies now have so many tools at their disposal to syndicate reviews, highlight reviews, and really use them as an endorsement of their product or service. So it's clear that the FTC wants companies to be honest and treat all reviews, positive and negative reviews, the same way. And as we previously mentioned, the updated endorsement guidelines make it clear that from the FTC's point of view, endorsements and testimonials are synonymous. They treat them the same. We think that this new rule pretty much puts reviews in that same line. And so although the title of the new rule is only speaking to consumer reviews and testimonials, we really think that they're getting at endorsements here as well. So we are currently in the public comment period for this notice of proposed rulemaking. That's open until September 29th. And then the FTC will take that all into consideration. So I'm going to go through some key takeaways from this new rule. So again, the FTC is really highlighting the fact that consumer reviews can have such a powerful impact on customer shopping habits. And so it's really trying to focus on two key areas of fake reviews and insider reviews. So the first area that this new rule focuses on is prohibiting companies from creating or writing a fake review or disseminating a review that it knows or should have known to be fake. So what is a fake review? Well, the rule tells us that a fake review is one that is by somebody who does not exist. So, someone pretends, creates a fake name, fake profile, creates a review. It is also one by somebody that does not actually use or have had any experience with the product or service or company that the review is about. So again, as we've seen in the endorsement guidelines, every endorsement review needs to be based on someone's honest and actual experience with the product. So if someone doesn't actually have never used the product or, that specific variation, then they shouldn't be providing a review about it. And lastly, fake review is one that materially misrepresents the reviewer's experience with the product. So if a customer, posts a long review and then a company just take snippets and it's not actually representative of what the reviewer said, that would be considered a fake review. The FTC has made it clear that these types of fake reviews are prevalent and that they need to combat this type of deceptive practice. And we've seen that in the actions that they've taken. And then now in this new rule, it's a big area of focus for them. Along those same lines, and something that we saw in the updated endorsement guidelines is the idea of insider reviews. So this goes to the same notion that if somebody has a material connection to a business that could have an impact on the viewer who is reviewing the review, who is seeing the review and taking it into consideration, and that should be disclosed. So the new rule would ensure that businesses inform their owners, officers, employees, any relative of such individual that they need to disclose the connection that they have to the business in their review, as that would be something that is important for a consumer to understand as they are taking a look at the review. We've actually seen the FTC settle several cases related to customer reviews that are alleged to be fake or unsupported. So in one case a few years ago, the FTC alleged that the cosmetic company Sunday Riley posted fake reviews to the Sephora.com website regarding its products. The FTC complaint alleged that the Sunday Riley owner sent emails to the employees, basically instructing them with step-by-step guidance of how to post fake reviews, create fictitious profiles, fictitious names, leave 5-star reviews to ensure that their products were highly rated. Additionally, the owner sent instructions for how employees could use ExpressVPN to hide their online activity. So again, the FTC found this to be extremely deceitful and wanted to take action. And did take action. And so the consent order notably did not include any monetary damages. However, 2 of the dissenting commissioners did think that Sunday Riley should have to pay some type of monetary fine. That said, there were a number of action items that Sunday Riley had to agree to take. So the consent order prohibits them from misrepresenting the status of any endorser or person leaving a review. It prohibits them from making a representation about any endorser without a clear and conspicuous disclosure regarding their relationship to the company. So again, now we know that means it has to be unavoidable. And lastly, it requires Sunday Riley to instruct their employees and agents to include this type of disclosure in any type of review that it leaves about their product. So again, all of these new takeaways that we're seeing in this new rule really stem from previous actions that we've seen the FTC take. So a few more key highlights. The new rule prohibits businesses from buying negative or positive reviews. It makes it clear that a company can't provide any type of incentive and condition it on a particular sentiment. So the company, while incentivized reviews are fine and businesses can send, free product or pay for a review, that has to be clearly and conspicuously disclosed. And the business can't instruct a reviewer to leave, any type of review, whether positive or negative, in any regard. Another big area, this is a new sort of key buzzword here, is no review hijacking. And so this occurs when a company uses a review that's written about one product for a different product that is materially different from the original. So if one product, has a ton of positive reviews, a company can't sort of borrow that for another product that is materially different. We typically see this happen on online marketplaces that have third-party sellers and vendors. So think of Amazon. If you consider their product pages, they are able to group different products together if they're only different in very specific and narrow ways, such as offering different quantities or colors or flavors of a product. But again, to the extent that products are materially different, we cannot sort of use this positive review halo from one product onto another. And the FTC initiated its first action in this case, and David's going to touch on that in just a bit. But a few more highlights from the new proposed rules. No selling or buying false indicators of social media influence. So, we've seen the FTC go after a company for selling fake followers, likes, views, all of that essentially. Again, the FTC wants businesses to be honest and transparent and not exaggerate or misrepresent the social influence that they have. And that's true for businesses and for influencers. The new rule also prohibits companies from creating or controlling websites or organizations or entities that are purportedly independent, but are actually reviewing the company's own products or services. And lastly, the new rule would prohibit negative review suppression. So again, as Libby mentioned, companies are able to, block reviews that are obscene or that aren't about the product at issue. But again, they have to do that on a neutral basis, and they can't only block negative reviews from being posted while keeping all of the positive reviews. Again, we've seen the FTC take action in this case. It's settled with online fashion retailer Fashion Nova for a pretty hefty monetary penalty of $4.2 million. So in this case, the FTC alleged that Fashion Nova misrepresented that its website reflected views of all purchases when, according to the complaint, Fashion Nova actually was working with a third-party online product review management interface that would automatically publish 4- and 5-star reviews and suppress anything less than 4 stars. So again, we see this as a high priority area for the FTC, grouping together consumer reviews, testimonials, and endorsements. And now I'm going to turn it over to David, who's going to talk a little bit more about similar enforcement actions in this space.
Thanks, Jenny. One of the questions that we get a lot from clients is, okay, we know the rules, or we think we know the rules, but some things happen, things slip up. Sometimes there's a difficulty in navigating an issue with an influencer. What are the consequences? What are the risks really? What does enforcement look like? And we are seeing, as many of you know, a fairly aggressive FTC in terms of enforcement. And the notice of rulemaking is indicative of an agency that wants to do even more. They could take the position, and they do take the position, that those issues with customer reviews are already subject to Section 5 of the FTC Act. It's deceptive, but they're trying to nail them down as specific rules. But they're not waiting to do enforcement. So, Jenny, as you mentioned, the FTC did look at this issue of review hijacking. And this is a really interesting issue because some of the issues with reviews, frankly, are somewhat common sense. Fake reviews, boosting only positive reviews and suppressing negative reviews. But when we're talking about hijacking, we're talking about leveraging a third-party retailer page in a sometimes subtle way to suggest that some product has more reviews than it does, or better reviews than it does. And in this case, we had a dietary supplement company, Bountiful. They had a number of supplement products, and they took advantage, allegedly, of Amazon's page, not just to suggest that other products had higher ratings than they did, but that brand new products that hadn't even really been on the market yet were tried and true, were seasoned, were popular. Amazon has a badge that indicates #1 bestseller for some varieties of product. But by lumping them together, according to the FTC, there was this, as you said, Jenny, a halo effect and a suggestion that those reviews and ratings applied to other products. And it's noteworthy here that these are health-related products that are advertising nutritional benefits. And there was evidence that this was an intentional act on the part of the defendant here. So this one settled about $600,000 in monetary relief. But again, this is an issue that we'll keep an eye on as we look for the proposed rulemaking to go into effect. If we can go to the next one, we've talked a lot about material connection and the disclosure issues and clear and conspicuous. And we've also talked about customer reviews. Obviously, these are very powerful tools because they go to the heart of why endorsements are so powerful. It is powerful to be able to sell your product by letting them know what consumers are experiencing, whether it's your friends, whether it's your favorite celebrities. That is the thing that has credibility, and it impacts the credibility to know if there is that material connection. What sometimes we lose sight of is some of the other rules with respect to testimonials and endorsements. FTC took action on Google and iHeartMedia, a radio network, for on-air endorsements of the Google Pixel 4 phone. And here we had a series of radio personalities that were paid to advertise the phone and to talk about their experience with the phone. But in some cases, these were recorded and these scripts were delivered before they were able to actually demonstrate that they used the phone. So this allegedly violates the rule that you have to be a bona fide user of the product. And if you're not, then your opinion is, according to the FTC, deceptive. So this is one that resulted in multi-million-dollar settlement, but on the basis of old rules, not really new rules. This is something that FTC might have found or might have pursued in any kind of medium. If we can go to the next slide. We talked a lot about FTC and the material connection issue. TeamET is the maker of tea products, and they made a number of health-related claims for tea products, and they used influencers to make them. And this is a case, and the FTC loves enforcement when they can dovetail numerous issues. So here we had health claims that they alleged may not have been substantiated, and they had influencers that were charged with failing to disclose material connections. And what's interesting about these cases, and obviously they go back a decade, these FTC cases on the material connections, is here there was a disclosure, but it was not clear and conspicuous. It didn't meet that standard. It certainly didn't meet the new unavoidable standard. A consumer would have had to click more options on the post to click through just to find that there was actually a paid relationship in a context where the FTC believed it was material and needed to be clearly and conspicuously disclosed. So again, we had consent settlements with the FTC. FTC, though, is not the only player in this space, but nevertheless, I'm going to mention them once more because they are part of your CLE Code. I'm going to read it aloud in case you're not watching. The CLE Code is FTC 822, FTC 822. Some of you may go ahead and grab lunch now, but I hope you stick around because we're going to try to get into what I think are some of the practical challenges that our clients face in this space. Some of the practical issues are the kinds of issues that we're seeing, not necessarily even from FTC enforcement, but from the NAD. And I want to talk briefly about the role of self-regulation when it comes to endorsements and testimonials. As some of you know, NAD is the National Advertising Division. It's the self-regulatory body that reviews advertising most of the time in competitor disputes. Sometimes, however, NAD does its own monitoring. They act almost like a mini FTC. They scan the marketplace. They look for issues where they think there may be problems or maybe deception or there may be controversy. And they ask these companies to participate. And they try to be ahead of the curve. They try to get involved in issues like endorsements and testimonials. And their role, although it's a voluntary process, their role is important in two important respects. Number one, when you're in their radar and they issue a decision, you get a lot of publicity. You may not want that if there's a finding that your disclosures were not good or that you were allegedly engaging in practices that were misleading consumers. But also companies that don't participate or don't follow NAD recommendations do get referred to the FTC. And this is a space where the FTC, we know, takes this issue seriously. So NAD looked at in part of their own initiative, investigated claims by the coldest water bottle. And there was a whole campaign here on TikTok where various social media influencers would be holding this, and it's sort of a metal insulated bottle, and they would be showing it, and they would have a tag, hashtag the coldest water. They wouldn't really be saying anything or making any overt claims, but NAD was concerned that this was an endorsement and there was no material connection disclosed. The company didn't want to participate. This was referred to the FTC, and the FTC put a little pressure on them, we think, because they ended up coming back to NAD. NAD reviewed the case, made some recommendations. Ultimately, NAD said that if in fact people are out there, touting this product and you don't have a relationship with them, it may not even be an endorsement. But to the extent they are receiving free product even, you have to provide them with instructions to make a disclosure of a material connection. And that's consistent with the FTC. The NAD tries to essentially enforce the FTC rules, but they try to do it sometimes on cases that are more on the margins, cases that on their own might not raise to the level of scrutiny on the part of the FTC. So that's why, in part, we need to keep our eye on where NAD is in this space. So there was another NAD monitoring case where, again, we see NAD looking at kind of more traditional issues with respect to endorsements and testimonials. Credit Associates is a debt relief company, and NAD, on their own initiative, was concerned about a number of claims being made on website and social media advertising, including the use of testimonials. And the testimonials they took issue with were the kind of testimonials, frankly, we see all the time. They're stories. They're stories about people's experience and the amount of money either that they saved or were able to refinance. And NAD's concern here was, we don't know if that's typical. And you, the advertiser, didn't provide evidence as to what is typical. Because under the rules, if you're going to be talking about, results that are extreme or are not typical, you need to disclose what kind of performance or results are typical. As a practical matter, that's sometimes easier said than done. But they're approaching this almost like it is a weight loss advertisement where, hey, we don't want you to be touting the extreme results if that is not typical and consumers would not otherwise understand that. So if we can go on to the next one, NAD is also getting involved in the space of product reviews. They were reviewing a cosmetic company called Pros, and this one was actually in response to a competitor challenge. And the claim that they were looking at was a claim about their reviews, 225,000 five-star product reviews. And what was interesting about these reviews is that these were reviews that were solicited reviews. Consumers bought the product and then received a survey. And in response to the survey, the company purportedly gathered and accumulated all these results and then came up with some data and said, here's a claim we can make. We figured that we have over 200,000 five-star reviews. We're going to say so. This is one also where NAD is trying to apply the FTC guides. And ultimately, they did find this to be a substantiated claim. But what was important about it was NAD went through that survey with a fine-tooth comb to make sure that what wasn't leading, to make sure that it didn't favor positive reviews, to make sure that it was conducted in response to good methods and practices. One of the great speakers from the FTC on this subject of consumer protection is Leslie Fair. And she's famous in her speeches for saying that the plural of anecdotes is not data. And that's the problem with customer reviews and using them in advertising. Now, I think we could sort of look at that a little bit differently. I think it's probably more accurate to say the plural of anecdotes may not be reliable data, but that's going to be the issue. And NAD is going to look at that survey and look at how the reviews were accumulated if you're going to make this kind of claim to be able to support it. If we can go on to the next one, this is an issue that we confront very often. And one of the challenges is companies know, or many of them do, that we've got to either disclose or tell our influencers that we're contracting with that they need to disclose a material connection in social media. And that could be a challenge depending on the platform. And what we've learned from the FTC is you cannot necessarily rely solely on the platform tools if the disclosure has to be made. You're on the hook if the communication isn't made in a clear and conspicuous way. And NAD got involved in this area too, where they looked at one of these dance contests, and this was Procter & Gamble using Bounty and using influencers, and you see the Bounty in the TikTok video. And on the video itself, there was a clear and conspicuous material connection disclosure. Hashtag Bounty Partner. We could talk about whether that does the job, but let's presume that that's good enough for our purposes here. The problem is when it gets shared, is that disclosure going to travel with the video? And it raises a lot of issues and challenges that came up when the FTC was looking at the revised guidelines, and it's created a lot of challenges for our clients. So Libby, let me kick it over to you to talk about some of those challenges.
So yeah, I did promise that I was going to talk about this earlier, and we're back. This is the tagging a brand in a post, but the question remains: is the material connection clear? I should note, by the way, importantly, we don't know if there's a material connection here. So I don't have the insider information. If somebody on this this webinar does, you can let us know. I think that by seeing enough of these things, our impression was that the bar provided some free merch to this influencer, and by showing the note saying, you know, we're launching this set, enjoy, babe, and her saying that she could never have enough of this brand, that we are supposed to understand that this was given to her for free in exchange for maybe hoping that she would post and kind of get the word out. That's not made clear though here. And I think that this is kind of one of these situations where we would say, like, is the material connection unavoidable? Is it not misleading? Do we know? I think the fact that the three lawyers you have on this call, and perhaps more lawyers we've got in attendance, aren't sure, makes it, you know, clear that you'd probably want to have a more obvious hashtag gifted ad, you know, disclosing the relationship here. If we can go to the next slide. Oh, this is very exciting. We have a video to show you. So to the, you know, if anybody's sort of like has their head spinning with lots of words, we can do pictures. If you wouldn't mind playing it, Jenny.
Summer is here, Chicago is back, and we're excited to enjoy all that our beautiful city offers. But while we're on the go enjoying Chicago, we also know how important it is to be ready to go if COVID-19 strikes. Speak with a healthcare professional about treatment options if you're at high risk of getting really sick from the virus. After a few years of experience with COVID, we know that with knowledge and preparation, we can enjoy the city we love. Visit noplango.com for more info.
So firstly, I picked that example because obviously it does show Chicago in a really positive light, which makes me as a Chicagoan very happy. It is really great here in the summer. You should all come visit. But beyond that, you know, I just wanted folks to take note of the sort of number of disclosures, right? We've got the paid partnership, the tool that Instagram offers up in the corner there, noting that this is a partnership with Pfizer. We've got a hashtag ad starting the caption. Then in the reel itself, at the start, you know, back on the start screen, I don't think we can go back to that, but it identifies that this is a partnership with Pfizer. And then we've also got this like whole disclaimer that sort of says, you know, speak to your healthcare provider. You know, it's different for everybody, sort of making it very clear. What we don't have is a verbal disclosure that Pfizer was the sponsoring entity here, even though technically speaking, you might say that she's sort of making claims that would drive that kind of disclosure. But I think this is a really interesting one to think, you know, is there anything that's avoidable or unclear about the disclosures that we've got here? Is there anything that misleading, you know, is there anything misleading that would suggest that, you know, you wouldn't understand that there was some sort of connection with Pfizer? So part of, you know, the analysis that we have to do and what we're going back to in all cases is always going to be context, and also, you know, and also common sense on sort of the question of what's misleading and what's not, and using multiple different ways to get across the fact that something is sponsored, is an ad, that there's a material connection, you know, may be enough if you're sort of hitting people over the head with it. You know, if you had maybe less of an obvious visual disclosure than is made in this, maybe that would elevate the need for verbal disclosure, right? So in some ways it's a balancing act, and I think that's important. But in any case, this is a really obvious example of ads. And if we go to the next slide, you know, I want to illustrate a point with this video and this static post on the right. Before we do the video of Bethany Frankel, I want you to know there's going to be some loud chewing noises in this video. So if you are offended by people chewing, you might want to mute for a second, but if you could play the video, Jenny.
Let's fight about my strange breakfast. Friendship. Roasted red peppers. Pine nuts. Everything bagel, a good one because it's not too many poppy seeds.
Sorry, Karen. So aside from the aggressive chewing, Bethany isn't doing anything, to our knowledge, wrong, because you don't have to disclose anything if you don't have a relationship with brands. So if she just is eating this breakfast and wants us to know some products she's using, and she's just showing the brands because she's just letting people in, there's no actual material connection there, and that's okay. But it highlights the need to have that disclosure when you do have the connection, because people are probably wondering. And an example of this is if we look at the post on the right, you'll note that it says, none of this is sponsored. I bought the shampoo and filter with my own money. And that's an interesting sort of sort of coming around full circle on what people may expect or not expect. This influencer feels the need to let us know that she's not sponsored, because otherwise there might be questions, where's your hashtag ad? Are you sponsored? What's the deal? Something that we talked about earlier, and that I think we'll continue to see sort of as people are deciding how to make these disclosures, is if it's so obvious that you think something is probably an ad, and you're kind of clamoring to have that hashtag ad as a consumer because you really believe that it was probably there's a relationship there, or you're sure that it must be a paid ad, is it really necessary? I mean, then are you being misled? It's an ad. But in this day and age, in the regulatory environment that we exist in, you want to make those relationships clear. But again, to the extent that influencers are out there and don't have a relationship with a brand, they don't need to disclose anything. And of course, they can also make comments that you might not want them making if you did have a relationship with them, but we're in a different playing field. I'm going to pass it. I'm going to do one more quick slide. This one, the takeaway here, the 10-second takeaway is button up your influencer agreements, right? Make sure that they match up with the new guidance. Make sure that you're laying out really clearly what you expect and the rules that influencers have to follow, and what's going to happen if they're not following that. So that as an advertiser, to the extent the FTC comes knocking or NAD comes knocking, you have a story to tell, right? We know it's not a safe harbor, but that having these kinds of guidelines in place may serve as a way to sort of tell a good story and get you out of trouble. Jenny, I'm going to turn it back to you for the last minute of this hour.
Perfect. Thanks, Libby. So one last issue that we wanted to highlight, again, a question that we see come up a lot with some of our clients is how can we disclose incentivized reviews on general shopping pages? So, typically when you just go to a landing page, it lists several different products as shown here. You can see it shows the star ratings as well as the number of reviews. One approach that we've seen some companies take is once you click into the product detail page, being pretty clear about the different types of reviews. This is a screenshot from Sephora. They actually have this whole ratings and reviews guidelines hyperlink that once you click into it, it explains, how customers should leave reviews, honest feedback about with the products that they actually have used. You can see that they have all of these different ways to sort down here. They are allowing customers to sort by non-incentivized reviews only. Again, there's little hyperlink that this tells you that if you click this, it will exclude any review from somebody that has been incentivized to leave a review, whether they received free product, money, a sweepstakes entry. And again, once you look at the individual reviews, they are labeling when it has been an incentivized review. So again, just thinking back to the story that you can tell, maybe you can't purchase the product on the general landing page. And then once you click into it and you're isolating one product, you can see all of the feedback and when something has been disclosed, or if there's material connection. So bottom line, endorsements are now defined very broadly, more than just words, can include a tag. Endorser covers a real person, any virtual influencers, animal influencers. Endorsers should disclose their connection, even if the advertiser doesn't control the message that they are putting out. Exact money doesn't need to be disclosed, although we will note that if an influencer or somebody receives product as well as monetary compensation, it may not be enough, or it is not enough, the FTC has said, just to say, I got this for free. So understanding, the different and multiple material connections that you have with the brand, or that a brand has with an influencer, is important to disclose. Again, these updated guides make it clear that everyone can be liable, whether it's the advertiser, the influencer, or the intermediary agency. And lastly, although it is not foolproof, but monitoring campaigns is recommended. So we hope this presentation was helpful. And if you have any questions, please feel free to reach out to any one of us. Thank you for joining.
Thanks, everybody.